Hey guys, this is Thiru Parmar back with the series where we are discussing IPR and Cyber Law 2016 paper solution. In last lecture, we have completed this solution till question number 2, sub-question B. That is, last we discussed about explain UK Data Protection Act. And in this series, we are going to continue a discussion with the question 2, sub-question C, that is discuss the digital copyright issues. So as we know, in today's era, we have multiple tools. If we want new release of a new copy of a new released movie, for example, any new movie, Bollywood or Hollywood movie, we can directly just download it from torrent, Pirate Bay, or we often use Telegram app as well, where we have many different groups or channels, we can say, where people used to share such things. So in today's era, it is very difficult when we talk about digital copyright issue. Now we have mobile as well. So with the help of mobile, using CamScan or any mobile app, one can easily create scanned copy of any textbook. So we cannot restrict others, but we have to put restrictions on such things. If we talk about one latest example, in Delhi Xerox Center, Rameshwar Photocopy versus Oxford and many other publishers, there was a case one registered in the year 2012 where this international publisher officially claimed that this Xerox Center um, uh, created a photocopy of their reference book, and this case was till in court from the year 2012, and recently only court just gave the judgment or a verdict on the same case in the year 2016, where as per the judgment, if anyone listen this statement carefully, if any person creates copy of any textbook, reference book, or any literary work, and if that copy is less than 10% or 10% or less than 10%, then that incident or that activity should not be considered as infringement of copyright, Indian Copyright Act. Now let's just discuss this question. Challenges of new technology. So internet has been described biggest copy machine, as we know. You just put anything on YouTube, on Facebook, or on WhatsApp, or on torrent, and as soon as we upload something, multiple people downloads and forward the same thing in different groups. At the same time, we have new compression technology where we can convert original movie like of 700 or 800 MB directly into mobile version. In technical words, we call it lossy compression, where we can compress something or some electronic material at such a way, such a limit where they can easily be shared or transferred via any particular medium. And at the same time, we can also apply lossless compression, where we zip file or we create WinRAR or 7-zip tools we use basically to share those files via many social networking sites. Now next is new tools allows modification of graphics, video and audio files. Scanners, as I already discussed, that using scanners or using your smartphone in today's time as well, one can easily create copy. At the same time, digital work are short-lived because they can be deleted, written over or corrupted without any advance warning because of some virus or any XYZ thing. I hope it is clear. Now let's discuss the second point in the same answer, digital copyright issue. Second is copyright law. Now, as we already know that we have signed WTO in the year 1995. India is one of the founder member of World Trade Organization, and under that WTO we signed one one treaty, you can say, which is named as TRIPS. TRIPS means trade related aspects of intellectual property right, where under this agreement we have established international levels rule by amending our local or India level rules. So we have also amended copyright rule. We have also amended this copyright rule with respect to align it with TRIPS agreement. So what is this all about? Copyright law, as you can see, we have revised and we have included software and database also in this particular amendment. High volume copying became now a infringement. Making multiple copies of operating system CD or many other things, that also considered to be a crime now onwards. So we have amended, as I said, we have signed WTO in the year 1995. Now remember, if we signed WTO in 1995 and under that WTO we have signed TRIPS agreement. So now onwards, whenever we talk about any intellectual property rule or act, those all act amended after 1995. So mostly if you say we have enacted a patent law in the year 1970 and then after signing WTO we have amended the same law in the year 1999. Copyright Act 1957 again amended after signing WTO TRIPS agreement in the year 1999, where we have make it compliant with the international rules which are focused basically or which are provided under the TRIPS agreement. So what are the new amendments or changes we have made in the copyright rule or act? So here, as you can see, definition given, nothing more difficult. As per the act, literary work. Now in the category called as literary work, we have included computer programs, then database, tables, and many other things. So basically, before 1999, there were very few people who were working with computer. As we know, computer or database or internet was not so popular before this, especially in India. So after the year 1999, during the year 1999, we have to add all these things, and again we have amended. Many amendments are there, but we are not concerned with respect to our subject. We only going to discuss with respect to this amendment only. So first we have added many other topics in a category called as literary work. Then we have also defined computer. Now remember, computer, it doesn't mean that one screen, one keyboard, one mouse and one cabinet. No, computer is any smart device which has integrated circuit built in and which can execute or process inputs given by user and generates a relevant output. So as you can see, as per the act, computer is a device which can be any electronic or similar equipment having information processing. Highlight this word, information processing capability. Now again, one more point added here, that as per the section 13A. Now, just for your information, then whenever we write answer in exam, remember this one point, that we are not using word article here. We often heard article 1, 2, 3 or some other articles. So if we are a cyber law student, so we should have at least a basic knowledge about when to use section and when to use article. Basically, there are three types of bodies categorized under Indian Constitution. So basically, one is constitutional act or rules. Basically, after amending Indian Constitution, we make some rules. So those rules or those acts are called as constitutional rules, or they are categorized under constitutional body. For example, GST is a constitutional body. So under GST we have rules, and those rules we basically describe as article 1, 2, 3 and many other. Then without amending Indian Constitution, if we made some rules, for example, Information Technology Act, same way Indian Patent Act, Indian Copyright Act. So we have not amended our constitution. Without amending Indian Constitution, we have made some rules or some act. Those rules or those act basically comes under statutory body. Clear? It comes under statutory body. So whenever we are talking about statutory rules or statutory law, that is Copyright Act is also a statutory law. So whenever we talk about this, under this we describe numbers with the word section, not article. Just remember this one point while writing an answer in exam as well. So here we are using word section, not article. Section we use if we are talking about constitutional amendment where we have made some changes in original Indian Constitution. Here we have not made any changes in Indian Constitution. We have separately we are dealing with, or separately we are making such rules. These are called as statutory rules or statutory law, or they are categorized under a statutory body. Clear enough? So here that's why we are using section word, not article word. So as per section 13 subsection A and section 2, this is subsection O of the Act, copyright is a computer program and its infringement will attract stringent penalty and civil sanctions. I urge you to at least remember these two numbers with respect to copyright. It is very difficult to remember all the words, but at least try to remember these two words. It would be really nice if you add the same point. It will help you to fetch more marks. Next is with regards to copying through electronic means. And last point is this includes communication through satellite or cable or any other means of simultaneous communication. So one cannot share, if you WhatsApp some new document or a PDF file or a scanned copy of any textbook. Let's suppose any IPR Cyber Law textbook, one of your friend created scanned copy with the help of cam scanner, and if you share it, then you are also liable for the punishment. So you are not allowed to share such things via any communication medium, not with the help of Facebook, not with the help of Twitter, not with the help of email, or not with the help of WhatsApp as well. I hope it is very clear. Now the last part of this question, so digital copyright issue, fourth part, where we are discussing about Digital Millennium Copyright Act. Now just remember one thing, whenever we add new some rules in India, so mainly we adopt those rules from many different countries, especially from UK, US. So the same way, this rule is also belongs to one of country where we have where those country created this rule for their own people. Now they already experimented with this rule, so whenever they have already experimented with this rule, then it is very easy for us because they already face some problems. So if we amend the same rule, then it is very easy for us, because without facing the same problem, we can add, or we can use those rules very properly. So let's start discussing the points given each. So some points added in Digital Millennium Copyright Act of the year 1998, that is, digital object can be subject to copyright. Any digital object, whether we talk about movie, some images, some files, some documents, anything, database as well, anything which is in a digital format. Disable anti-piracy functionality or that copy digital objects. Then the same way, digital anti-piracy functionality or the copy digital object except research and educational purpose. So we cannot use any digital object except for research or for educational purpose, and that is also educational purpose, not with respect to classes or something which purely works for commercial reasons. We can use those things in some government or some educational purpose, like in government schools and colleges. It is acceptable to make a backup copy of digital object, like we can create a backup server for our database, but it is not allowed to create backup of your operating system CD. It is different from this, right? So if we are creating backup for our database, it is allowed. It is not allowed to create backup for any software CD which you have purchased. And last thing, libraries can make up to 3 copies of digital object leading to other library. So for example, I have made some research paper on any IT based subject, then library where I have kept my theses or my reports or my research papers for others reference, they can at max create 3 copies of this, not more than 3 copies. If they create more than 3 copies of the same, then they are liable for punishment, or that particular pattern considered to be infringement of Digital Millennium Copyright Act, and as per the punishment defined or penalty defined under this, they are liable for the same punishment. So here we are done with this question. In next video, I'll continue with the last question, last part of question 2. Thank you.